And Andrew Weissman here, Laura Jarrett is inside the courtroom, and she's describing the judge's affect, that he was speaking slowly, as you've heard inside and I heard inside. He speaks very calmly and slowly and deliberately, even when he was chiding the defense lawyer or the prosecution in various instances.
Right. I really wish for that reason that at least there was an audio.
I mean, the Supreme Court audio has been so helpful to us.
Exactly. You can actually simultaneously listen to arguments now. And one of the more striking things is hearing Judge Merchan's voice at a time when there's so much distrust in our legal system being fomented by Donald Trump and others. It would be so helpful to hear that, because that was the first thing that struck me. Laura's reporting in terms of what was going on this morning, which was the reading for about an hour of the jury instructions and the jurors being rapt to attention, makes total sense. I mean, this is when they actually find, what is the law? What do they have to find or not find? So they're given all these instructions, and the reporting is that they were paying very, very close attention to that, as you would expect.
And describe the rapport between the judge and the jurors in this case, in many cases.
Yeah, I mean, almost all jurors, unless you've got a really erratic judge, develop a real bond with the judge. The judge, he or she, is looking out for the jurors. They're just paying careful attention to their time, is making things move along. And with, as you've noted, with respect to Judge Merchan, I mean, I am like now, I have like a man crush on him.
Right.
He is such a great judge that it's hard to see that the jurors wouldn't have the same impression. I mean, you just keep on thinking, if you looked in a dictionary for like judicial temperament, that's what you get. And just remember, he has had to put up with a defendant who committed 10 acts of contempt, who's threatened not just him, but his family. And in spite of all of that, you would not know for a second that is in any way weighing on him, because it has just been such an impeccably fair trial. Which is,
just a fascinating context here, especially given all of the ruckus and social media and outside the courtroom. Judge Jones, talk about that. So what is the most critical part of the jury instructions that you saw today, and how they could sway the outcome? Did any side benefit at all from the way the judge described the law here?
Well, first of all, Andrew is precisely correct. I want to just comment on that. Jurors do cleave to the trial judge, and particularly this trial judge, who was so even-tempered and I thought did an exemplary job with a tough case. Andrew couldn't be more correct. As far as the instructions are concerned, I think the instructions on the law itself, broad as they were, giving the jury some room to find these underlying so-called predicate crimes, those are very, very important in the jury's deliberations. And unfortunately, in New York, you can't take the instructions to the jury room with you. We did that in the federal system, as your panelists know, and that was always helpful to the jury, but you have what you have. I do think there's going to be some questions. No juror, lawyer, or otherwise can memorize pages and pages of intricate law. And unfortunately, that may slow the deliberations. But otherwise, I think it's the substantive law, the law of the case, as we call it, that is going to be most important in the deliberations.
And there was a slight delay in them actually starting to deliberate, I should point out, because two of the jurors needed instructions on how to use the laptop, which had the evidence loaded. Jeremy, let's talk about all of that. I mean, this brings it all home to all of us who've dealt with technology as things have evolved, but there were two jurors who were not that familiar with the laptop.
So it's funny is not the right word, but I just recently had a trial in Brooklyn Supreme Court where the jury wanted to access certain things with the computer. And what they have to do, meaning the court system and the district attorney's office as well, is to make sure, and the defense, is that laptop is clean. It's not internet accessible. There's nothing on there other than whatever tool or whatever they need to look at is on that laptop. And believe it or not, it took us probably 3 or 4 hours for the court system in the state of New York or the city of New York to get a laptop, to clean it up, to make sure it was accessible and usable. And while there was a delay, at least initially, it's a really effective tool for a jury to use to synthesize what they need to, and then move that ball forward to either an acquittal or conviction.
And another little bit of housekeeping. There are 6 alternates, and it was notable to me that they were not dismissed as the deliberations started. They can't participate in deliberations. Are they being kept in case someone gets sick and then they could be brought up to speed? I mean, is there...
And again, I'll use the term funny. That's exactly what happened in my most recent trial. I lost one, and then I lost a second juror, and one of the jurors was substituted. Doesn't matter. Ultimately, the other juror came back, but they're critical, but they're not involved in that initial deliberation. They're separate and apart. But they also have to be involved in that entirety of the deliberation. They don't just come on at the end and say, we have 11 jurors, you're the 12th, what do you want to do? They have to be immersed in that process to ensure that the accused has that fair due process rights and that case is proven beyond a reasonable doubt.
So, Barb, we just got the transcript, as we do on a somewhat delayed basis, 55 pages of the judge's instructions that lasted a little more than an hour. A partial verdict is a possibility. Let's talk about the first 7 counts. They're tied to the 2 checks that were not signed by Donald Trump. So even if the jury finds him not guilty on those first counts, it could change. It could all change on count 8. Could you break it down for us?
Yeah, absolutely. Each of these 34 counts has to be looked at individually. And so it seems quite possible that the jury could find guilt on some counts and not guilt proven on other counts. In fact, in some ways, if you're an appellate lawyer, this is a godsend. It's a gift because it demonstrates that the jury did not look at it in an all or nothing fashion, but carefully looked and parsed each count in the indictment. And so, for example, it could be that the jury finds, as you said, the signed checks show guilt and Donald Trump's direct participation. Unsigned checks, maybe there's a reasonable doubt. Same with regard to invoices and ledger entries, where the prosecution's theory is that Donald Trump caused them to be created, but didn't create them himself. And so I think the strength of the evidence is strongest on the checks that he signed himself. I think there's certainly evidence on the other documents that he caused them to be executed. But you're right, Andrea, that the jury will have to look at each of these individual. But from the prosecution's perspective, guilt on any one count is success because that brings with it a felony conviction. And so although there's 34 ways to guilty here, guilt on even one count is a conviction for the former president.
And Judge Jones, how much influence will the judge have, especially if the jury comes back with questions at various times?
Well, I don't think influence would be exactly the correct word, Andrea. I think it's up to the judge to take the questions, for example, coalesce with the lawyers and find the right way to answer the questions and not to show that he's leaning one way or the other with respect to the answers. And it's kind of an art form to do it. There are some questions, as your panelists know, that judges, after coalescing with the attorneys, have to say to the jury, I'm sorry, but I just can't answer that question for you. It's not an appropriate question. It's out of bounds. I'm going to instruct you to go back to the jury room and continue to deliberate. So how he manages the jury is going to really help the jury in its deliberations generally, but I don't think he'll influence the jury. He doesn't want to influence the jury. They're the finders of fact, per se. I expect, given his qualifications, his vast experience as a trial judge, he knows exactly what he's doing. He's in the moment, and he'll handle inquiries from the jury very, very well.